And at this time, I'd like to welcome to the stage to introduce our next speaker, NIEDA Legislative and Regulatory Counsel, Sean Peterson. Sean? Thank you. Appreciate that. Yeah, thank you.
Today, we're excited to have our next speaker join us as well. The Department of Justice has been very active in our industry over the course of the past year, including its first ever settlement enforcement action against a buy here, pay here dealer. We are privileged to have with us Steve Rosenbaum, who is the Chief of the Housing and Civil Enforcement Section in the Civil Rights Division of the United States Department of Justice. He has been the chief of that section since April 2003. That section is responsible for enforcing the Fair Housing Act, the Equal Credit Opportunity Act, Title II of the Civil Rights Act of 1964, and the Religious Land Use and Institutionalized Persons Act. Under Steve's leadership, this section has created over 12,000 housing opportunities for persons with disabilities through the enforcement of Fair Housing Act's multifamily housing accessibility requirements. Their section has filed and settled 3 major fair lending cases, including the first cases in which the department has alleged discriminatory redlining regarding consumer or small business loans, one of the issues in this buy here, pay here case that Steve will talk to us about. They've obtained a $1.1 million verdict in a sexual harassment case, which is the largest verdict the department has ever obtained in a fair housing case. They filed and settled a case alleging racial discrimination in public accommodations against a large national restaurant chain. Steve is a 28-year veteran of the Civil Rights Division who has served as chief of 2 other sections in the department, including the Special Litigation Section and the Voting Section. He's been lead counsel on some of the division's most demanding and complex litigation in previous positions in the appellate, voting, employment litigation sections. He is the recipient of the Walter W. Barnett Award, which is the division's highest achievement, highest achievement for recognition in litigation. He's been honored with numerous special achievement, special commendation, and senior executive service performance awards. Steve was born in Brooklyn. He received his Bachelor of Arts in History with honors from Binghamton University. He attended the University of Michigan Law School, which please do not hold that against him. OHIO, right? Give it to me, Buckeyes. We are excited to have Steve join us today. Steve has agreed to take questions at the end of his presentation, so as you hear him, I encourage you to jot down some questions that you have, and we'll open up the microphone for those questions at the end of his presentation. Join me in welcoming Steve Rosenbaum.
Thank you, Sean. Thanks to all of you for having me here today. That was a very kind, generous introduction, not least because of all the nice things he said about me, but also because he shaved 8 years off my life. I'm actually a 36-year veteran of the Civil Rights Division. So every time I come to Las Vegas, I am struck when you fly in by how close everything looks together. There it is, the Empire State Building and the Eiffel Tower. They're right across the street from each other. And then you get in a cab and you pay the cab fare, and then you start walking around, like from the front of this building to where we are here, and my Fitbit is very happy with me today, and you realize that the spaces in Las Vegas are vast. Well, I think I would flip that in terms of our relationship, the Justice Department and NIEDA. It may seem like the distance is vast, and I hope by the end of the talk we've narrowed the distance quite a bit. My goal is to tell you about the laws we enforce, to give you some idea of things you should not do and things you can do, and to work with you. I grew up in a modest household. My parents never bought a new car. We were only used car. I remember my dad was proud. His last used car was only 5 years old. So I know the importance from personal experience, but I also know the importance of your dealerships and the market you deal in. People can't get their kids to school, to daycare, to jobs without access to a car, and the buy here, pay here dealerships are the place to go for many people with poor credit histories. You're a significant player in the used car industry. According to your website, You're responsible for $3 to $4 million in automobile sales. That's about 10 to 15% of the market, and nearly $100 billion in outstanding automobile contracts at any one time. So, auto lending has been a focus for the Justice Department for a while. It's the focus of other regulators, the CFPB and the FTC. And we have been working in tandem with those agencies over time, but particularly in the auto lending space in the last few years. So here's what I'm going to talk about. I'm going to talk about two statutes, the Equal Credit Opportunity Act, also known as ACOA, and the Service Members Civil Relief Act, also known as the SCRA. And I'm going to talk about two kinds of violations under ACOA, three kinds: reverse redlining, pricing discrimination, and source of income discrimination. And under the SCRA, I'm going to talk about issues related to repossessions and the right that service members have to have their interest rates on loans reduced. The goal is to give you the power to know what it is that you need to do to comply with these laws. So let's begin. As Sean said, we filed a case against a Buy Here, Pay Here dealership, our first in 2014, and it was for something called reverse redlining. So let me take a stab at explaining to you what that is. So first of all, there's redlining. That is when lenders, it started actually with our federal government in the 1930s, when the government got into financing or backing up financing of home loan mortgages. They actually drew red lines around neighborhoods and said these were not neighborhoods in which they would guarantee loans, and those were neighborhoods that were largely minority neighborhoods. So redlining derives its name from that source. There were literally red lines on maps about where the federal government wouldn't support mortgage lending. So redlining is not doing business on equal terms or not doing business at all in a particular geographic area because of the race of the residents who live there. Reverse redlining is when you choose to market in a minority neighborhood because of the race of the residents there. And that part is just fine. I'm probably going to say that about 3 times during my remarks. Choosing to locate and market in a minority neighborhood is just fine. What makes it reverse redlining is when you make that choice in order to market unfair and predatory loans to those two people in minority neighborhoods. So let's drill down a little bit. What are unfair and predatory lending practices? Well, they include originating loans with grossly unfavorable terms, setting exorbitant interest rates, excess fees, or issuing those loans without any regard to a borrower's ability to repay. Unfair and predatory practices also include servicing loans in an unfair and predatory manner, including when servicing loans in default and conducting repossessions. Let me go into some of the details of the case in Charlotte. And in describing what we found, I want to be clear, these are allegations in a complaint. The complaint was litigated for a while, and we were able to reach a settlement with the dealership. So these are allegations, but they're important because they were important to us in terms of why we brought the case. They were also important because the judge ruled that these allegations were sufficient to state a claim of reverse redlining under the Equal Credit Opportunity Act. So there were 2 dealerships, 1 principal. The unfair and predatory practices are failure to meaningfully assess the customer's ability to repay the loan, sales prices in excess of industry standards and far in excess of the wholesale price, disproportionately high down payments compared to similar dealers, disproportionate high interest rates compared to similar dealers, usually set right at the state's usury limit, disproportionately high default and repossession rates compared to similar dealers, with the majority of loans entering default, repossessions occurring when customers were not in default at the time of repossession, installing GPS devices without notice to the customer and using the devices to locate cars for repossession, failing to comply with state repossession laws, including failing to provide sufficient notice failure to pay surplus, and failure to return property found in the car. The allegation about, and I should mention that our suit we were joined in our suit by the Attorney General of North Carolina, who was enforcing the state repossession laws, among other laws. The claim that the two dealerships targeted African-American customers were based on the following allegations. Dealerships were located in heavily African-American neighborhoods, and the dealership's owner made statements which included the use of racial epithets, indicating that he was specifically interested in African-American customers because he perceived them to be of inferior intellect and to have fewer options for credit, and that he employed a particular sales agent because the agent was especially adept at getting African Americans to buy cars. So as I said, the case was litigated for a while, and the court ruled that we had stated a claim of reverse redlining, and then we rolled up our sleeves and worked with the dealer and his lawyers to come to a settlement. So when we do settlements, we are trying to remedy what happened in the past and make sure bad things don't happen in the future. Some of it has this is what the law requires component. Some of it has a prophylactic component. This is a dealer who had done bad in the past, so we want to build a bigger fence around what the law may otherwise require to make sure he doesn't do bad again. So before I get into the specific, the important thing to notice, our goal was not to put him out of business. Those dealerships we never advocated closing them. They are still in existence. Our goal was to have those dealerships run in a way that comply with the fair lending laws. So these are the practices that are in the settlement, the new practices. So the dealer now has to obtain documentation that shows the customer's ability to repay, including that the car payments do not exceed 25% of the documented net income. The standard interest rate charge will be 5 percentage points below the state usury limit, so it'll typically be at 24%. In addition, the dealers agreed to reduce the interest rate an additional 3 percentage points, typically to 21%, when a customer poses less credit risk, as documented by things like exceeding the posted down payment by 50%, documenting average monthly income above $2,499, being a repeat customer with no prior defaults, providing a credit report showing at least a 550 FICO score. In addition, the dealers have to offer competitive sale prices that are within 15% of the NADA retail value are presumed to be competitive, not charge fees at the time of sale other than government-imposed, tax tag and title fees, disclose any GPS or automatic shutoff devices, offer a test drive and a chance to obtain inspection from a mechanic of the customer's choice, offer at the customer's expense a Carfax-like report, and provide non-discrimination notices to each customer, as well as posting the notice in the dealerships. With regard to repossessions, the agreement requires that there are no repossessions for payment default until 2 consecutive missed payments. You have to mail a written notice to the customer's last known address. You have to refund 30% of the down payment minus reasonable fees incurred in repossession for repossessions that based on non-payment within 45 days of the sale, unless the customer drove over 2,000 miles. So what are we getting at? What we think was happening in this particular dealership is that they were churning the sales. They were getting high down payments, putting people in loans they couldn't afford. They knew they were going to repossess. They repossessed, they collected, if they could, the repossession fees, and then they put the car back on the market, sold it for a higher than usual down payment to someone who couldn't afford. So churning the car and getting multiple down payments on the car in a relatively short period of time was part of the business operations. The only repossession fees that could be charged were those allowed by the state repossession law, and then some other things that deal with the state requirements. In addition, there's a $225,000 fund for us to be able to compensate victims who appeared in the past. So I said at the outset, not all of these things, I can tell you, are required by the Equal Credit Opportunity Act. Some of these are prophylactic. Some of these may be best practices. It is our hope that dealers who are doing things right are doing many of these things already. It's also our hope that other buy here, pay here dealerships will evaluate their practices in light of the problems we found in this set of dealerships and in light of the settlement. So I told you I was going to repeat this several times, so this is the second time I'm saying this. ACOA's prohibition on reverse redlining allows lenders to aggressively seek to serve minority borrowers, heavily advertise in minority communities, and have a high percentage of minority borrowers. These steps, when taken by creditors with responsible lending practices, offering loans with fair terms, are precisely what the federal law seeks to achieve by prohibiting lending discrimination. ACOA also allows creditors to offer loans with less favorable but fair terms to customers who pose a higher credit risk based on legitimate objective measures of credit. So we know that there's risk-based pricing going on in some segments of the auto market, and that's okay. It's how you do it that can sometimes run afoul of the problem. So that's reverse redlining. Moving now to discretionary pricing, a model that exists, I think, in some parts of the buy here, pay here network, probably more predominant in other marketing. But let me talk about it a bit, because I think it encapsulates one area of fair lending risk, and that is discretion. It has been our experience and the other federal government regulators' experience that giving people discretion in the prices they set for loans and the fees they set for loans is a fair lending risk. ACOA doesn't require that you give discretion in setting those things. It doesn't prohibit giving people who you employ discretion in setting interest rates and loans. But we know from experience that if there isn't guidance in how that discretion is exercised, if there isn't monitoring of how that discretion is exercised, if there aren't steps to rectify problems that are unveiled by the training and the monitoring, then you're running a fairly decent risk that you're going to end up charging minority borrowers who are equally qualified for the loan more money for the loan. And so we've seen that in the mortgage lending space. We've seen it in the auto lending space, particularly in the indirect auto lending space, where the auto dealers are negotiating. They get a buy rate from a different set of direct lenders, and then they are told they're allowed to mark up that rate by typically either 200 basis points or 250 basis points, depending on the length of the loan. So 200 basis points is more common as the life of the loans for new cars gets stretched out. We think it's fine for dealers. The model itself is not a problem. We think it's fine for auto dealers to be compensated for their role in bringing the loan to a direct lender. They are doing activity that deserves compensation, but this high markups system without careful monitoring of the discretion is a credit risk. The National Automobiles Association has a fair credit pricing policy, which we think is a promising development. It's a mechanism for guiding when you can lower if you're starting at 200 basis points, it's guidance on who gets their price lowered and why, and documentation. So objective features offered to everybody that are legitimate business reasons are included there. So if you're in that kind of market, I would suggest you look there. So that's a solution that keeps the current caps, that holds some promise. We have also seen lenders go to a non-discretionary pricing system where everybody gets a flat fee. The dealers get a flat fee for bringing the loan in. And we've recently seen some movement to, or consideration of movement to, a lower cap model. And our experience and the CFPB's experience is that if you lower the caps, CFPB says lower the 200 to 100 or so, you're going to eliminate or at least significantly reduce any disparities that you would typically find. So that, in a nutshell, is discretionary pricing. The third form of discrimination under the Equal Credit Opportunity Act that I want to mention is source of income discrimination. So, for example, the Equal Credit Opportunity Act does not allow discrimination based upon the receipt of public assistance income. Typically, these are things like Social Security disability income, Social Security retirement income. If you have a policy that prohibits lending to people who have that income, who would otherwise qualify, that's a problem. You shouldn't do that. So I think that's probably all I need to say about that. If the income is verified and it's an income level that you would otherwise give people loans, you should give people loans if it's SSDI or SSSI. So let me shift now to the Service Member Civil Relief Act. It's a statute that has a long history in our country. The animating force behind it is people who are in the service on behalf of all of us should not have to worry about things that are going on at home and should have their lives at home simplified while they are in the armed forces. So there are two in particular that apply to the auto lending setting. One is on repossessions. You cannot do a non-judicial repossession against someone who's in the military service, okay? Most states allow non-judicial repossessions. If someone is in the military service, you cannot do that. And the reason is when you file an action, a collection action, against an active duty service member, the statute gives that service member some protections. They can have the hearings postponed, they can have a lawyer appointed to represent them in their hearings, they have a mechanism to allow the court to consider, for example, the decrease in income as a result of joining the service that has caused the repossession, and all those rights are lost if there's a non-judicial repossession. So how do you know if someone's in the military service? Well, sometimes they tell you when they're buying the car and signing the loan note. But the Department of Defense has a database. The acronym is DMDC. It's available to anyone. If you have Social Security number and date of birth and the name, you can find out whether someone's in the military service or not. And then there are some mechanisms to see if you need to know how long they've been in military service. So recently, just a few months ago, we had a settlement with Santander Consumer USA, not our first, but our biggest case, focusing on auto repossessions. And we found that they were systematically doing non-judicial repossessions from people they knew or should have known were in the military service. The typical relief we have obtained, and we did obtain in this case, is to require Santander to pay about $10,000 for most people who were harmed, plus if the repo sale produced any net value to the purchaser, to have that go back to the service member. So like in the buy here, pay here case, we try to design a system that would work going forward for Santander, worth looking at for other people who are doing repossessions. So we said that Santander had to check the military database, the DMDC database, at 3 points in time: before referring the loan for repossession, right after obtaining possession of vehicle, and right before disposing of the vehicle. They cannot refer loans for repossession or continue with the repossession process when the military database shows coverage. And they must return the vehicle to the owner if the military database shows coverage, but the creditor nevertheless obtained repossession. You can take possession of a vehicle that has been impounded by an unrelated third party if the military database shows coverage, but you can't do a repo unless you go to court. And any waiver of the service member's rights in this regard must provide specific information about the SCRA's protections and must be signed after the service member has entered military service. So the second SCRA right that I want to make sure you all know about is the right for service members who took out the loan pre-service and then go into military service to have their interest rate, including fees, lowered to 6%. So it doesn't matter where it starts. It could start at 20, 24, 15, 10. If the loan was pre-service and then the service member goes in, the service member is entitled to a reduction to 6% as long as they stay in military service. The statute says that the service member should provide notice of military service to the creditor in order to get this interest rate reduction, but the notice doesn't have to be in any specific form. And the service member should provide a copy of the military orders to prove that they're in military service. But one of the things that we've been doing in order to make it easier, make clear that it should be easier for service members to obtain this benefit, is to suggest that lenders check the database themselves on their own initiative without waiting for a notice from the service member or without waiting for a copy of the military orders. And if the DMDC database shows it was a pre-service loan and the person's in active duty service, then reduce the rate to 6%. That's reflected in our settlement on student lending with Sallie Mae. It's reflected in the Department of Education's new guidance to loans that it's own. It's something similar is reflected in agreement some of the largest mortgage servicers made voluntarily with the White House earlier this year. So I think that's the trend, and there's legislation on that issue that being considered that would move the whole statute in that direction. So how do you stay out of trouble? There must be better ways than listening to me talk at you for a half hour. I would suggest to you that running the business the way your code of conduct says you should run the business will keep you out of trouble. Your code of conduct says you have to comply with federal and state laws. Your code of conduct says you don't put people into loans that they can't afford to repay. And it is in your business interest to have repeat customers, to have people who leave the experience of dealing with you feel good about that experience, so they tell friends and neighbors, and they come back to you when it's time for them to buy a new car. So drill that down a bit. One of the things you can do is respond effectively to customer complaints. Not only does it prompt repeat business and referrals, but customers who feel they were treated poorly may assume that the dealer was treating them poorly for discriminatory reasons or for improper reasons. And so just being responsive to complaints and working with customers and explaining why you did what you did, if something was done that was wrong, fixing it quickly, all those things will keep you out of trouble. Ensure that you're offering responsible lending products with fair terms. The closer you flirt with legal limits, the greater your risk of discrimination. But nobody's going to fault you for making a fair loan to anybody. If you've got a system that allows for discretion in pricing, manage that system. Know when discretion is being used. Provide the people who exercise that discretion some guidance on what's appropriate and inappropriate in exercising that discretion. And then look back at what they did periodically and see if you can pick up any concerns or any trends in the exercise of discretion. One of the things that you may not be aware of is that a COA requires you to keep records of all review of applications and handling of opening accounts. Retaining credit applications for 25 months is required. So you should be doing that. As I mentioned in talking about the SCRA, regularly checking the military database is easy to do. It is essential before proceeding with repossessions that are not filed in court. And it is a good practice in terms of proactively providing that benefit to service members who are entitled to a 6% rate reduction. And finally, in the unlikely event that you do draw the attention from the Civil Rights Division or another government regulator, even after following my advice, cooperate with the investigations. We actually are reasonable folks. We approach investigations with an open mind. We want to understand how you do business. We want to understand how you make decisions. And I can assure you that not every investigation we open, including not every investigation of a Buy Here, Pay Here dealership, has resulted in a lawsuit. We really do look, we try to have sufficient evidence to bother you in the first place, but we approach these with an open mind. We know what we know. There's a lot that we don't know. We want to be fair to the consumer, but we also want to be fair to the people we investigate. So thank you for your attention. And now I am happy to, at least I will start out being happy, to take questions. And this is my special one-time offer for all the members of NADA. I will not ask you to tell me your name or the name of your dealership.
Hi, good morning.
Good morning.
You mentioned about the pricing discrimination on making profit, the dealer making profit on the 200 points on the approval rate. I didn't understand if it's illegal to charge these 200 points or...
No, what's illegal is when you're charging up to 200 basis points, having that practice result in minority borrowers paying higher interest rates than non-minority borrowers. So it's not the fact that charging 200 basis point increase is okay, as long as it doesn't result in discrimination. But keep in mind, the dynamic is the dealer doesn't tell the potential borrower, I got this rate from this bank at 4%. I only have to charge you 4%, but I can charge you 6%. That's not the conversation that goes on. Our view is that the 4% buy rate that the lenders, indirect lenders, set is the one that's based on creditworthiness. The rest is based on negotiations, perceptions about negotiation ability, and if that process results, if you use that process and there's not discrimination, there's not disparities based on race, that's fine. If there is, we're going to ask how that resulted. And that's sort of what the NADA credit policy is about. They say if you document when you exercise discretion, then you will have, and only allow it for specified categories, then you will have an explanation if there ends up being racial or ethnic disparities.
So if you charge to everybody those 200 points, and somebody with better skill negotiations, you drop it a little bit of that, and you charge only 150, it's not going to be, as long as there is no discrimination, it's okay.
As long as there's no discrimination, there's okay.
Okay, okay, thank you.
Yes, does this work? Yes, I'm curious. You mentioned the dealers in North Carolina. How did they come to your attention?
What I can say is we get information from lots of sources. So sometimes we, if we're not dealing with an auto dealer, we don't get information from the bank regulatory agencies, although we did get a referral on an indirect lender, and we started looking at the dealerships who were using that indirect lender. People can write to us. People can write to the CFPB. People call our office and tell us about their experiences. And so we can read newspaper articles. We have conversations with State AG's office, who may be looking at problems they're seeing in dealerships. So it's a variety of sources. We don't need a formal complaint under our statutes to open an investigation. Sometimes we have them, sometimes we don't.
When you were discussing the revert under repossession, as part of the settlement, I believe you said that you required the dealership to send a note to the customer's last known address, but you didn't describe what kind of note. Is that an intent to sell property, or what's the intent of that note?
It's a note that's intended to provide the opportunity to cure within 15 days of the mailing.
First of all, thanks for being here. I appreciate your comments. I appreciate the tenor of your talk. I think by definition, everybody that's here wants to do the right thing, and they want to know what the laws are, and they want to comply. And we want to help you get the bad guys because we know that we're out there. My question is, I want to ask a little bit more about the concept of disparate impact. What I glean from some regulatory agencies that if you have, let's say, 100 minority borrowers and 100 non-minority borrowers, and this group has some objective criteria that makes them a higher credit risk, a lower beacon score, lower income, whatever, is that there is no defense to disparate impact. If you're charging a higher rate to these borrowers, it doesn't matter that it's objective. You're doing something wrong. Can you address that?
Yeah, let me try to break that down a bit, and I'll speak for the way the Justice Department approaches it. So there are interest rates that are set based upon creditworthiness factors, and we have not challenged disparities that are based upon creditworthiness factors such as FICO scores, debt-to-income ratio, loan-to-value ratio, the kinds of factors that are typically considered in lending. There's a theory by which you could challenge them. The Justice Department never has. Where we have found problems both in mortgage lending and in auto lending is the part of the pricing component that is unrelated to creditworthiness factors. So it's the 200 basis points in the indirect loans, in auto, it's in mortgage lending. They may get, the mortgage broker or the loan officer may get a par value of 6%, and then they're told you can go up or you can go down. And then it's that negotiation, that unstructured discretion that is not related to the creditworthiness factors, because that goes into the buy rate, that goes into the par rate, but not into the negotiation process that occurs after the buy rate or the par rate is set. And with regard to the discretionary pricing, where there is a disparate impact, the law says you can justify that disparate impact based upon legitimate business reasons. And so if you look, and I'm not saying the NADA policy is a complete defense, it's out there, but the NADA policy is designed to, if you follow it, to provide a justification that is legitimate and non-discriminatory if disparities arise in the discretionary component of the pricing. And we met with the NADA representatives when they were developing it. We've talked about it publicly. So in sum, the Justice Department, have not challenged the use of legitimate creditworthiness factors in setting a rate that may vary, even by race, in the aggregate. But where we have looked at is how the discretion is exercised on top of the buy rate or the par rate.
Yes, could you give me that website again to see if whether they're in the military?
Sure. You want the whole one? It's www.dmdc.osd.mil/appi/SCRA. But I think if you just go Google DMDC, you'll get to the website you need to get to.
Hi, I'm a buy here, pay here dealer. I want to clarify the source of income discrimination that you were talking about.
Sure.
Some of my customers who are unbankable aren't able to get traditional loans. We do deny certain type of occupations, pizza deliveries, customers, delivery, strippers, certain incomes we won't do. Would that fall under this category?
I'm trying to figure out the equivalency between pizza delivery and stripping.
Well, source of income. Unverifiable income.
Yeah. That's source of income is sort of a term of art that's used about the specific protections, and that principally in the ACOA deals with public assistance income. So you can't discriminate against someone because they get public assistance income. But what you do based on however you verify based on jobs, or whether you can verify that there is income that's going to be coming forward, that's not covered by what I was describing.
When you say this disparate impact applies to minorities, would it also apply to other groups like, say, women or the very old, the very young, or
Yes.
same-sex couples, that sort of thing?
Well, the statute prohibits discrimination based on age, which for ACOA purposes is 62. It prohibits sex discrimination. It prohibits discrimination based on race, national origin, religion. So any of those categories could be susceptible to a disparate impact analysis. Typically, what we've seen in the auto lending space is we've been looking at differences between whites, blacks, Hispanics, and Asians.
Thank you.
Clarification on the military. Active duty can be a 9-to-5 job if you're here in the States. And then a deployment, you're told you're getting spun up, you're being deployed. That is when your income, if you're a reservist, can significantly change. So these new laws that are going into place, are they for military members who are being deployed, or is it just military across the board?
It's just military service. You have the benefit of no non-judicial repossessions, and you have the benefit of the 6% interest rate reduction by being in military service. You don't have to be deployed to get those benefits.
So we could sit here and take questions all afternoon, and we're grateful that Steve is here and willing to do that. We'll have to make, in the interest of time, we'll have to make this our last question.
Make it a good one.
I don't know whether to stand up or not. On the repo, with people without insurance, we check insurance weekly, daily, and then we notice they're out of insurance. So we're allowing somebody to drive a car with no insurance. And of course, we're the lien holder. My purpose is make sure they have insurance. We call them up. We give them the 24 hours to prove it. And if they don't prove it, then we go get the car. Is that legal?
Well, whether it's legal or not would depend on state law. As to military, you might be able to take the car, but you're not allowed to put it through repossession. You can't put it through repossession without going to court first.
All right, thank you very much for these wonderful questions. Let's give Steve a big round of applause. Thank him for his time and coming to join us today.
Thank you very much.